You made such a remarkable and flattering introduction today, and I'm very honored and very happy to be with you here today. And I see that we have a really big audience today of some 19 or so participants on this subject matter, recognition and enforcement of foreign judgments, which I will talk about today. And I will particularly focus the issue of reciprocity in this context, which is, so to speak, a cornerstone of the whole dogmatical and doctrinal treatment of the issue of recognition and enforcement of foreign judgments, which belongs, of course, to international civil procedural law, one can say, in our context, and thus is part of private international law in the broader context of the common law understanding. You may be aware of the fact that in the common law systems, private international law refers to basically three issues. Number one, the determination of jurisdiction in cases with foreign elements. Number two, the determination of the applicable law in a particular case of the substantive law. Number three, recognition and enforcement of foreign judgments. Those are the three topics of PIL, as the common lawyers abbreviate that. The understanding is different, though, in civil law countries of the continental European origin, because there, in the old Roman law tradition, there is a very strong differentiation and delineation between public law and private law, and the determination of jurisdiction, as well as recognition and enforcement of foreign judgments, are matters of procedural law and thus of public law, you see. And only the determination of the applicable law is private international law in the narrower sense of conflicts of law. So much as to the dogmatical categorization or systematization. Now, my idea is that you just let me go talking for about an hour or a little bit more about my subject. We would then perhaps make a break of some 10 or 15 minutes, if it is all right with you. And after the break, I would like to continue. But at the end of the lecture, there will be ample room. There will be ample room for questions and comments on your side, and also of discussions of the issues that I have been talking about. I will start to tackle the topic in a somewhat unusual way, perhaps, because I will firstly concentrate on what the present situation in China is about with regard to recognition and enforcement of foreign judgments. Because I think that you therefore and hereby have a more easier access to the subject matter when we then switch over to international questions, particularly to how other countries deal with our subject matter. China. In case that you have attended my lecture on arbitration about 2 or so weeks ago, and on international commercial arbitration, you may have heard about the so-called New York Convention of 1958, dealing with the recognition and enforcement of foreign arbitral awards, making hereby this recognition and enforcement of, so to speak, private judgments issued by non-state courts very uncomplicated and easy among the more than 150 states of this convention. And China has
Recording in progress.
been a contracting state of the New York Convention, thus allowing recognition and enforcement of foreign arbitral awards in China. However, in the, one can say, ordinary case of recognition and enforcement of foreign state court judgments, things are different. There is not such a convention around so far that China has already signed and ratified. And therefore, everything belongs basically to the international civil procedure law of China. And generally speaking, Chinese courts would only recognize and enforce a foreign judgment on the basis of the provisions given in this civil procedure law, respectively on the basis of bilateral treaties. Insofar, it is not simply restricted. As of today, China has entered into about 40 bilateral treaties with other countries for recognition and enforcement of their judgments. But for those countries with which China does not have a bilateral treaty, and which include certainly major investment partners, including the United States and also including Germany, the parties would need to rely on the famous principle of reciprocity, which means a principle of mutuality, which means basically I will only recognize your judgments if you recognize vice versa my judgments. I will come back to that, and I will treat today the principle of reciprocity intensively. This principle of reciprocity has always been subject to judicial interpretation by the local people's courts on a case-by-case basis. Generally speaking, the application of a foreign company, particularly for recognition and enforcement of a foreign judgment in China, carries a statutory limitation period of 2 years, running usually from the issuance of the judgment. This is the limitation period, which is, by the way, considerably shorter than in many other countries. In preparing for the application, the parties are required to provide for a translation by a certified translator of all the non-Chinese documents relating to the proceeding, and parties therefore then must go on to apply for the recognition and enforcement within this limitation period. Now, one can say that based on this aforementioned principle of reciprocity and the principle of sovereignty, a judgment issued by a court can only be recognized and enforced generally in its own country, except for the provisions and for particular treaties mentioned. If one has a closer look, there are three basic conditions for Chinese courts to recognize and enforce foreign civil and commercial judgments. And of course, we concentrate here on civil and commercial law judgments. The first condition is that the foreign civil and commercial judgment has taken legal effect, which means it must be a definite, a final judgment. This is, in a way, self-evident. Secondly, China has concluded, as I mentioned, or joined an international treaty on the recognition and enforcement of civil and commercial judgments with a lot of foreign countries. And if one party belongs to one of these countries to which China is linked by a treaty, then we find the requirements and conditions in this treaty. If that is not the case, then the basic idea of reciprocal relationship matters. Thirdly, the recognition and enforcement of the foreign civil and commercial judgment shall not violate the basic principles of law, which means no violation of the public order of China must be found, which is also self-evident these days and is based on the national sovereignty, security, and social and public interest of the countries. The procedural requirements on recognition and enforcement of foreign judgments then go a little bit more into detail and include that the applicant may be a party to a case of a foreign court, and that the court to which the application is made is an intermediate people's court with jurisdiction. Thirdly, the applicant materials must be translated into Chinese, of course, and recognition and enforcement of foreign judgments shall be made in the form of an enforcement order. Now, one can say that the People's Court, the Supreme People's Court, also has given important interpretations on the application of the civil procedure law of the People's Republic of China, which provide a supplementary hints and tricks and treats, so to speak, on the treatment of the issue of recognition and enforcement of foreign judgments. Among them is that the applicant shall submit a written application to which the original or the certified duplicate and Chinese translation of the effective judgment shall be affixed. And second, that the People's Court shall, from a collegial bench to examine the case, and the People's Court shall serve the written application upon the respondent. Those are more, one can say, technical details, which perhaps we should not dwell so much on today. One can say that the preparedness, willingness, and readiness of China to recognize and enforce foreign judgments has been remarkably increased in the last years. And this is certainly true with regard to ordinary foreign civil and commercial judgments, as well as with civil compensation in criminal judgments and bankruptcy judgments. However, the relevant judgments of intellectual property cases and unfair competition cases, as well as anti-monopoly cases or antitrust issues, will not be recognized and enforced in China due to the geographical attributes and particularity thereof. The courts will recognize and enforce foreign judgments, nevertheless, only on the basis of the principle of reciprocity. This reciprocity issue will be in the center of today's lecture. I will soon revert on that. One can say that the general idea is, if there is a reciprocal understanding or consensus between China and the country where the judgment is rendered or issued, then China can recognize and enforce the country, the judgment of that country. There is practically no realistic chance to abstain from that, in the sense that the Chinese court has only a very limited scope for a review of the judgment concerned. Chinese courts usually do not conduct a substantive review on foreign judgments. In other words, Chinese courts would not examine whether foreign judgments make mistakes in fact-finding or in the application of law. They will refuse to recognize the applicant's foreign judgment only under very narrow circumstances. As I mentioned already, in accordance with the law of the People's Republic of China, the court, if the foreign court has no jurisdiction over the case, in fact, that the case, that the judgment has not been rendered by a capable foreign court, then of course that would be a reason to reject recognition and enforcement. The same thing is true in cases where the defendant did not receive proper notice of the judicial proceeding or have a reasonable opportunity to argue, which means in cases where the right to be heard is violated. Also in cases where it is clearly at hand that the judgment is obtained by fraud or bribery. Those are reasons for a Chinese court to reject recognition and enforcement. But those are, of course, very, very rare circumstances, and normally the recognition and enforcement is then granted either on the basis of a treaty or on the basis of the principle of reciprocity. Now, let us now, after this little survey on what the situation in China is basically about, have a closer look on the general ideas, principles, and on also the international circumstances which matter in this respect. We must be aware, dear students, that the judgments of one state have no force by themselves in other states. This is due to the principle of territoriality, which governs the entire public law. All the acts of a state are limited to the territory of this state. It is perfectly clear. If, for example, you walk about in Wuhan and would perhaps meet at a junction of several streets a French policeman trying to regulate the traffic in his French uniform, you would not pay attention. You simply would say to this guy that he has no say in China, that he has no power and no right and no capacity to regulate the traffic in China as a French policeman. And in the same thing is true with other acts of states, like the issuance of a judgment. After all, a judgment is the outcome of the judiciary, and the judiciary is one of the three state powers, as you know, which means that we are dealing here with an act of state limited in its effects to the territory of this state. Nevertheless, this restriction is sometimes or often unsatisfactory because parties themselves are interested in transnational legal certainty and in avoiding repeated litigation in different countries with perhaps even conflicting decisions. This is the reason that there is an interest in avoiding resources spent on re-litigation, and this is the reason for an interest in international decisional harmony. On the other hand, states can have valid reasons to deny foreign judgments, at least to deny them the same force they grant their own judgments, since foreign procedure may be viewed as deficient, or the outcome of the foreign litigation may be viewed as not in accordance with one's own values or objectionable on other grounds. The field of recognition and enforcement of foreign judgments tries, therefore, to balance different interests. When dealing with recognition and enforcement, we must realize that normally the recognition comes first and the enforcement second. That is at least the case with regard to all judgments that are enforceable, particularly with judgments sounding in money, you see. Nevertheless, we always speak of recognition and enforcement, and hereby insist on a differentiation, the reason being that there are some judgments which are not enforceable, but only recognizable. For example, in the field of family law, if you have a judgment about the validity of a marriage, then this judgment is recognizable and not enforceable. Or if you have a judgment on the membership of a particular person in a company, again, this is recognizable, but not enforceable. So to speak, status decisions are only recognizable, whereas basically monetary orders, judgments sounding in money, are open to enforcement. And that's the reason why we are speaking here of the two aspects of recognition and enforcement. Now, as you can easily imagine, that in the law of recognition and enforcement of judgments, we can speak of a growing importance in our world in which persons and assets can easily be moved across the borders, and the recognition of foreign judgments makes it harder for losing defendants to avoid liability. And the short view on the history makes it aware that we are dealing with not a really new, but in fact with a traditional subject matter. It is not such a new topic. In fact, already in the Roman law, some 2000 years ago, the issue has come up. And it was at that stage already that the sovereignty of a state mattered fundamentally. And this then led to the outcome of the principle of reciprocity, to which I will now draw your attention. Because one can say that recognition and enforcement of foreign judgments, as we have seen, when having a closer look at the beginning on the situation in China, that the law of recognition and enforcement of foreign judgment is governed by the two principles, interwoven principles, no doubt, of sovereignty and reciprocity. And the principle of reciprocity, of course, is a matter by far exceeding just our topic. It plays a vastly important role in international public law, in general, even in political international relations. One can encounter it in private international law also, and just as frequently as in politics. It really appears only in the field of conflict of laws, in the narrower sense of the applicability, as we will soon see. But it still constitutes, for some, if not many, countries, as it is the case in China, in the absence of bilateral or multilateral treaties on recognition and enforcement of judgments, a crucial condition to the recognition and enforcement of foreign judgments. Comparing different legal systems, no uniform rule will become apparent as to under which conditions foreign judgments can be recognized and enforced. Nevertheless, the little catalogue which I have introduced to you with regard to China resembles very much the catalogue also in other countries. And there are no doubt exceptions. For example, some countries, like North Korea, do not respect foreign judgments at all. Then the majority of countries is bound by bilateral treaties, respectively international conventions, or, as we will also see with regard to the European Union, by supranational law. In some legal systems, it is anything but clear whether effect can be given to foreign judgments. determining whether a foreign judgment is to be given effect or not can be particularly difficult and cumbersome if national law requires the state of rendition to grant reciprocity. The court or the pertinent other authority, as we will see, may have to study foreign procedural law and find out whether it is whether its own decisions would be recognized and enforced in return, so that one can say reciprocity is granted. Now, the term reciprocity is a very general term, and I think it's worthwhile to have a closer look on this terminology, because the term reciprocity is used in different scientific disciplines and is thus a little bit ambiguous, and it's certainly worth to look at it. In general, reciprocity describes a symmetrical behavior or a position, an identical response to an action adopted by another party in a particular situation, which implies a relationship between mutual actions and reactions. In the world of law, reciprocity has been defined or described as the mutual concession of advantages or privileges for the purpose of commercial or diplomatic or legal relations. And that is, of course, coming very close to our understanding and to the understanding of the Chinese law on recognition and enforcement of foreign judgments. It is widely applied in the context of international relations. Reciprocity, nevertheless, plays a significant role in many parts of public international law. For example, a state, by insisting on reciprocity, makes a privileged treatment of foreigners from various states within its own territory, dependent on the same treatment of its own residents in the respective foreign states. Now, this reveals already that reciprocity is or can be used as an instrument of exerting pressure and as a means of retention, in fact. Essentially, the principle is based on a simple rule colloquially called quid pro quo, or do it des, which means I do something because and only if you do something. So mutual exchange, so to speak. Or to put it in a different terminology, a state is willing to grant particular rights to a foreigner only on the condition that the foreigner's state shows the same consideration to the first state's citizens in return. And this objective can be achieved in several ways. By unilateral domestic codified law, as in the civil procedural rules of a country, or by, of course, international treaties, respectively conventions, but also, of course, by usage, customs, and practice, which means by cooperation. As you can already see, dear students, Reciprocity is based on sovereignty and is closely linked to sovereignty. Sovereignty simply meaning that a state has power over its own territory and its subjects. That it is exclusively legitimized to issue laws, carry out acts of state, and exercise authority in this state. Nevertheless, cross-border state activities and cross-border trade expanding so rapidly in recent decades and citizens has brought about the legal issue of cooperation in this respect. And this is where the reciprocity requirement basically has its origin. From a historical perspective, one can say that the cooperation and the idea of reciprocity was for a long time based on discretion or simply on friendliness and obligingness among the countries. The basic notion and idea was that the states normally explained, I am only friendly if you are friendly too, you see. Reciprocity as a fundamental principle or as a legal doctrine only arose in modern times and along with sovereignty and nationalism and self-government. Sovereignty linked legal cross-border cooperation is insofar the foundation of reciprocity. A state pursuing, first of all, its own interests is only willing, ready and prepared to waive partly its sovereignty and accepts the same rules and make equal concessions on this basis. Pride and pressure are behind this reciprocity principle, but also, of course, cooperative goodwill and encouragement. In respect of international relations, lawmakers originally employed the reciprocity requirement to facilitate legal transactions by providing equality and by encouraging states to conduct their affairs uniformly regarding legal issues. At this point, I must draw your attention on a most fascinating fact, namely that in the field of private international law, in the narrower sense of conflicts of law, or in the narrower sense of the determination of the applicable law, the applicable substantive law in a particular case, the reciprocity principle does not matter at all. The existence of the reciprocity principle can be perhaps traced back also in this field some 2,000 years ago, but in recent times, which means in the last 200, 300, 400 years, the reciprocity principle does not play any role in the determination of the applicable law in any of the countries. That is, no doubt remarkable. Legislators and courts noticed, in fact, and acknowledged in this field of application of foreign law that fair decisions and appropriate results can only be achieved considering carefully all of the potentially involved foreign legal systems, and did not look at reciprocity. Since every sovereign nation possesses inherently exclusive jurisdiction, the acceptance and application of foreign law appeared not as a surrender sacrificing public authority or national sovereignty, but as a matter of comity and of willingness and of preparedness, and as a matter of goodwill. It was the aforementioned idea of comity, of friendliness among nations. And according to the notion of comity, a sovereign state voluntarily applies the law of another state and hereby abandons to this extent its own authority. And this approach then was even mitigated under the new doctrine of private international law, according to which the new conflict of law rules have been developed, denoting only the issue of applicability of law in the narrower sense, and hereby looking at certain connecting factors. And insofar, we find today in the field of private international law, in narrower sense of determination of the applicable law, no mentioning and no value and no importance at all of the principle of reciprocity. Now, with regard to our subject matter, namely recognition and enforcement of foreign judgments, things are indeed different. The idea of reciprocity still lingers on because we are dealing here with a matter of public and not of private international law in the narrower sense. And insofar, the basic considerations are shaped differently. One can say that according to the systematic doctrinal categories of many countries, issues of recognition and enforcement of foreign judgments do not belong to private international law in the narrower sense as part of civil and private law, but to international civil procedure law as part of procedural and thus public law. And that, of course, then leads more or less automatically to the greater importance of public interests of the state that matter then more. Of course, at the outset, it is the interest of private parties which is at stake primarily. After all, a claimant, plaintiff, or creditor may have obtained a judgment sounding in money in his favor and then discover that the respondent, respectively defendant and debtor, along with his assets, has gone away, has escaped to another state. The creditor may even have obtained a judgment against a party residing in a different state at the time of the suit and beginning of the trial. The judgment therefore becomes a futile threat a blunt word, so to speak, are useless in the state where it was handed down and where, due to the lack of assets, execution cannot be performed. Yet the creditor cannot be left without a remedy in such a case, and that's the reason why most legal systems are willing to recognize, enforce, and consequently give effect to foreign judgments, provided certain conditions, as we have seen at the example of China, are met. Which means generally that recognition and enforcement do never occur automatically, but are subject to an internal procedure, which is designated to scrutinize whether certain conditions are satisfied, and which ends up usually with the issuance of an ex equatur order. Ex equatur order, meaning, so to speak, this is a Latin phrase, meaning it may be executed, ex equatur. And this execution order transfers, so to speak, the foreign judgment into the domestic legal system, and hereby partly appropriates it or adopts it. And it is in exactly this context that reciprocity plays such a crucial role in many states, namely as an additional and indispensable requirement for an ex equatur order. The requirement of reciprocity must be complied with, even if the state has no doubts that the foreign judgment is actually correct on the merits, and even if it stems from a country with basically the same or similar social, political, or ethical attitudes or values. And even if it is fully in conformity with the demands of fair and just proceedings. Now, it is not easy. It is not easy to really justify the requirement of reciprocity. Considering the main political, economic, and legal objectives with which most states pursue in the field of recognition and enforcement of foreign judgments. Indeed, dear students, and that is what my basic point of today's lecture is about, there are convincing reasons, if not perhaps compelling reasons, for a state to engage in the recognition and enforcement of foreign judgments, notwithstanding any requirement of reciprocity. This is what the essence of today's lecture is about. I would like to offer you and to plead energetically for an abolition of the idea and principle of reciprocity in connection with recognition and enforcement of foreign judgments. That already is clearly becoming obvious as most appropriate on the basis of the following deliberations and examples. Look, in filing for recognition, a claimant may seek primarily to preclude relitigation of claims or legal issues previously decided in a foreign court. The foreign judgment shall thus induce the same legal effect as it would unfold in the pronouncing state. For some types of for some types of judgments, for example, declaratory judgments, judgments without relief, it is sufficient to be just recognized. More judgments and the majority, especially those sounding in money, as I told you, necessitate more than just an official declaration of the claimant's entitlement, since the debtors do often enough not pay voluntarily. And to satisfy the party's interest, full and final relief needs to be granted then by enforcement. Regularly, recognition and enforcement go therefore hand in hand. The former is only a preparatory step for the latter. With regards particularly to judgments sounding in money, recognition and enforcement of foreign judgments serve evidently to protect the creditor's private interests and to prevent the debtor's dissolution of assets. The state requested by a party to issue an exequatur order can hardly deny that the recognition and enforcement of a foreign judgment serve also its public interest in providing legal certainty and clarity. This can perhaps best be exemplified by our judgments in marital and in family matters after a foreign court or another appropriate body has dissolved a marriage. One of the parties may want to move to another country and enter into a new marriage abroad. If the state then does not recognize the foreign divorce, it obviously denies the person's right to remarry. Hence, the person has a different marital status in the two countries involved. Legal certainty and clarity is left behind. Generally speaking, recognition and enforcement of foreign judgments is to avoid multiple proceedings and concurrent litigation with potentially contradictory decisions on the merits. Insofar with regard to clarity, certainty, and efficiency, the recognition and enforcement process is favorable for the claimant, for the state courts, and for the states involved, irrespective of and notwithstanding with the idea of reciprocity. Now, as we already know, every state has its particular rules or provisions governing the recognition and enforcement of foreign judgments. And to find out whether a foreign judgment will be recognized and enforced in a court of a particular country, one must investigate the pertinent law applicable to recognition and enforcement of foreign judgments. And if there is a bilateral or multilateral treaty or convention governing recognition and enforcement in existence, then those provisions apply. Now, it is in this context, dear students, that mention must be made of the European law and the new Brussels regulation of 2012, which Professor Hang Chi-Hui has already mentioned and which entered into force in January 2015 and which has now seen a recast already in relatively due time and which therefore is of high importance among the 27 member states of the European Union, because all member states of the European Union are subject to this regulation in respect of jurisdiction and the recognition and enforcement of judgments on commercial and civil matters. As it is the case with all regulations, this Brussels 1A or 1 bis regulation is self-executory and immediately applicable in all member states of the Union. And it harmonizes among the 27 member states the national rules on recognition and enforcement of foreign judgments with regard only to the 26 neighbor states of each particular other state. It contains this Brussels 1A regulation of several chapters. One chapter, namely chapter 3, governs recognition and enforcement in the member states, hereby replacing, harmonizing, and at the same time replacing the national laws. And according to section 37, paragraph 1, a judgment given in a member state shall be recognized in the other member states without any special procedure being required. And section 39 states then that a judgment given in a member state which is enforceable in that member state shall be enforceable in the other member states without any declaration of enforceability being required. The member state examines only whether judgments in the sense of the regulation and its formal procedural requirements is in question. And the court or other respective body is obliged then to enforce the foreign judgments in the same way and under the same rules and procedures as it would do in case of a domestic judgment. The same principle applies as it would do in case of a domestic judgment, and this same applies to another member state's judgments. Now, this is what Professor Wang Xinghui has rightfully called free movement of judgments. By this regulation in the Brussels 1A rules, we find, so to speak, an addition to the 4 fundamental freedoms of the internal market of the European Union. You all are familiar, I guess, with the 4 fundamental freedoms, namely freedom of movement of persons, freedom of movement of capital, freedom of movement of goods, and freedom of movement of services. Those are the 4 basic free movement principles which we have in the internal market of the European Union, and they are now being flanked and supported by this idea of a free movement of judgments, meaning that the one state of the European Union treats a judgment of another state of the European Union like an own domestic judgment without any additional requirement, particularly without any additional requirement of an exequatur stem, and seemingly without a requirement of reciprocity, seemingly. Look, one must say that this Brussels 1A regulation has triumphantly been celebrated as an abolition of the old exequatur requirement. That is certainly true. There is no formal procedure anymore. On the contrary, this new regulation provides just for a limited number where one can apply for a rejection, hereby shifting the burden of proof to the other party, namely the debtor party, and hereby, so to speak, reversing the idea of the burden of proof with regard to recognition and enforcement of foreign judgments. And insofar, it is no doubt a triumph. But if you have a closer look, the reciprocity requirement is certainly not abolished. The truth is that the regulation has only incorporated the reciprocity requirement and thereby made it in a way invisible. Although the regulation does not expressly notice reciprocity as a requirement, the principle of reciprocity is evidently inherent in its provisions because the member states are prepared to give up their sovereignty only because the other member states are bound likewise and will do the same. All member states sacrifice their sovereignty to the same extent. The regulation guarantees every member state that its judgments will be respected and executed in other member states as well. But this procedural Brussels 1A regulation does not follow an universalistic approach extending its application to third states. That is not the case. The regulation Brussels 1A is restricted to internal EU issues, as were already its predecessors, the Brussels 1 regulation of 2011, which Professor Huang mentioned, and the former Brussels Convention of 1968, which was just a convention in the sense of an international treaty and not a supranational instrument and vehicle of EU lawmaking, you see. Now, insofar, by the way, the Brussels 1A regulation differs, of course, from the Rome 1 and the Rome 2 regulations on the law applicable to contractual, respectively non-contractual obligations, because these applications, these regulations on the applicable law are universalistic. They follow a universalistic approach, extending their application even to third countries. That is, of course, a major difference. Now, with regard to the Brussels 1A regulation, one must say that the principle of reciprocity is inherent and has not been abolished. By the way, the same thing is true with the other multilateral conventions on the matter. The Hague Convention on the Recognition and Enforcement of Foreign Judgments in Civil and Commercial Matters, which Professor Huang also mentioned, and comparable conventions like the Lugano Convention on Jurisdiction and Enforcement of Judgments in Civil Law Matters or the other so-called New York Convention on the Recognition and Enforcement on Foreign Arbitral Awards, they all, without mentioning the reciprocity principle, indeed include this principle and make it invisible, but it is always inherent. That is something that I want to draw your close attention to. And insofar, although one can celebrate this regulation, Brussels 1A, no doubt as a breakthrough, as a breakthrough with regard to the free movement of judgments within the 27 member states, there is no doubt that the reciprocity principle is still inherent. And that is something which now leads us to the situation where no supranational regulation or international treaty or convention governing the recognition and enforcement of foreign judgments is in existence, or when a particular issue falls outside its scope of application. Then, of course, always the concrete requirements must be looked up in the respective domestic law of procedure. Very few national laws refuse to recognize and enforce foreign judgments entirely, as it is the case with North Korea, for example, with the consequence that the plaintiff then has to initiate possibly proceedings against in the state where it seeks to obtain an order of execution. Most states impose strict conditions, as we have seen with regards to the People's Republic of China. In the absence of foreign, in the absence of international bilateral or multilateral treaties, we have a catalog of conditions, including at the first, in the first place, the reciprocity requirement. Now, I think we have deserved a short break here, and after the break, I would like to continue with a closer look on some countries, what they do with regard to the recognition and enforcement of foreign judgments in the absence of the applicability of a bilateral or multilateral treaty, respectively, in the absence of a supranational vehicle like the Brussels 1A regulation. And I would therefore like you to enjoy the break, invite you to enjoy the break, and in about 10 or 15 minutes, it will be a pleasure to continue and to see you again.
Okay, see you later, Professor.
See you later. of reciprocity in the recognition and enforcement of foreign judgments because, as you have already certainly discovered, the reciprocity requirement is in the center of today's interest and of the considerations on how to deal with recognition and enforcement of foreign judgments also in future. In the first part of our lecture, we have had a look on the situation in the People's Republic of China with regard to recognition and enforcement of foreign judgments. We have scrutinized the requirements which the civil procedural law of China provides for in the absence of bilateral or multilateral treaties with other countries on this matter. And then we have turned our attention to the general issues of this field of international procedure, civil procedural law, to which the recognition and enforcement of foreign judgments belongs. In the last part, we have scrutinized the Brussels 1A or recast regulation on jurisdiction and recognition and enforcement of foreign judgments, and have discovered that the reciprocity principle is still inherent in this regulation, although in general one must say that it has provided for a breakthrough in that it now abstains from the old and important requirement of a exequatur stamp. In fact, in the old times, the requirement of exequatur was honestly a double requirement. On the one hand, the person, normally the creditor of a particular judgment, had to prove that the judgment was enforceable in the issuing or rendering state, and then ask for another exequatur requirement in the state of recognition, respectively enforcement. Now, as I introduced, let us now have a closer look on the situation in some of the countries of our modern world, how they deal with our topic of recognition and enforcement of foreign judgments, and particularly with the requirement of reciprocity. And then we will have a general look on the justification of this principle. That is the way I would like to proceed now. Let us have a look first on the so-called Germanic countries in continental Europe, by which I normally refer to Germany, Austria, and Switzerland. One can speak of them as the core Germanic civil law countries, but there are also flanking states like Denmark, partly the Netherlands, and apart from that, also Turkey can be seen in this context. Now, in the German law, reciprocity is well established in the field of recognition and enforcement of foreign judgments. We have a particular section, the number doesn't matter, but it is section 328 of our civil procedure law, which governs recognition of foreign judgments. Here we find the details, namely that recognition and enforcement of foreign judgments is based on the same reasoning, and that is that it is a necessary condition that we also find reciprocity with the other country. A foreign judgment can only be recognized and enforced if the judgment is final and conclusive in respect of the law of the pronouncing court. Then a German court will abstain from reviewing the foreign judgment on the merits. And then, in the absence of such a scrutiny, the central requirement is that reciprocity is granted. And insofar, we again encounter basically the same requirements which we have already seen in the Chinese law. In the Chinese law on the recognition and enforcement of foreign judgments, we find also this number one requirement that the judgment must be final, that is not subject any longer to appeal, respectively revision, but that it is subject to the application of res judicata. The thing must be final and conclusive. Then also we have in the Chinese law, to the same extent like in the German law, the requirement that the rendering court must have jurisdiction in the light of the international requirements of jurisdiction. Also, the third requirement stated in section 328 of the Civil Procedure Law of Germany is basically reflected in the Chinese law, namely that the defendant must have had proper notice and that there was no violation of the right to be heard. And the fourth requirement is something which is not expressly mentioned in the Chinese law, but some of the courts in their interpretation, some of the people's courts in their interpretation have also insisted on this requirement, number 4, namely that there was no conflicting domestic or foreign judgment in existence. Then, of course, no incompatibility with the public policy. That is a universal requirement for all laws. I don't know of any law without this requirement. No incompatibility with public policy of the country where relief is sought. And then number 7, reciprocity. As in China, also Germany insists on reciprocity. And if all these requirements are fulfilled, then exequatur stamp is being granted with regard to third countries. Always remember that Germany is, of course, member of the European Union, and among the 27 member states of the European Union, of course, the Brussels 1A regulation applies, which means insofar these ordinary requirements which we find in the Civil Procedure Court are being replaced. But this is only true among the 28 member states because of its restriction of the Brussels 1 recast to or the territory and the membership of those 20 states. So that the requirements we are now talking about only govern in cases where third states are involved. Then one can say that the situation is very similar in our neighbor country, Austria, also being, by the way, a member state of the European Union. The reciprocity requirement applies to foreign judgments sought to be enforced in Austria. I don't want to dwell on the details, but there is a particular Austrian Enforcement Regulation Act, and insofar a special statute in addition to the civil procedure law of Austria. But now, a most remarkable exception is Switzerland. Despite originating from the same legal family, namely the Germanic legal family, the Swiss law does not require reciprocity for the recognition and enforcement of foreign judgments. One can say that the Swiss private international law insofar was influenced by, as we will see later, the French approach, definitely influenced by the French approach, in that in the absence of an international treaty, the matter is governed by the Act on Private International Law, and recognition is and enforcement are not governed by the reciprocity principle. The treatment of condition of recognition and of enforcement is the same. The conditions for recognition are that the foreign court had international jurisdiction, the judgment is final and conclusive again, was not obtained by fraud, and complies with the Swiss Ordre Public. We know this catalogue from China as well as from Germany. And a recognized judgment can then be enforced. There is not any mention of reciprocity. Now, due to the lack of codified law regarding our field of recognition and enforcement, the most important source for dealing with this field is in France, the case law. France has no provisions in their civil procedure law, but in the case law, we find, of course, the pertinent rules. In the old times, French courts have had a really liberal approach in this respect. If the adjudication of a foreign court was marked by international jurisdiction, then its judgment was perfectly unquestionably recognized and enforced by French courts. And there were no further conditions. France was insofar always a country characterized by a great deal of comity, of friendliness. Nevertheless, in the old days, that is. Nevertheless, this principle was significantly modified in already the 17th century, according to a new order of the King Carol at that time. And according to this order, the courts neither recognized nor enforced then for a certain time any foreign judgments, and so far the pure contrary was the case. And if a successful foreign claimant wanted to obtain any relief in France, he had to institute legal actions in a French court again and accept a new result. In some circumstances, even an unfavorable new result. But that again was then finally overruled in the beginning of the 20th century by the Cour de Cassation, the Supreme Court of France, where two decisions have been issued according to which the French ordre public method, also the foreign court must have had international jurisdiction, and also the foreign must have applied the proper law even, which was, so to speak, an additional prerequisite. But then there was no mentioning of any reciprocity. And insofar French was indeed a pioneer in that it is here, as always, regarded as the motherland of the Romanic law family. And akin to the French position, Spanish law also did not insist on, does not insist on the reciprocity requirement anymore. And the same thing is true with Italy. I don't want to mention the details, but one can say that particularly with regard to France as a pioneer country, the reciprocity requirement is endangered in the European continental law, even with regard to third states. Now, what is the case with the United Kingdom? Now, here we find a very special situation to which I must draw your attention because it is, in a way, a peculiar and unique. It is a totally different approach from what the continental European law has developed in our field of recognition and enforcement of foreign judgment. Namely, in the United Kingdom, we have the peculiar, some people say peculiar idea that the judgment is not enforced as an act of state of the a state where the judgment has been issued, and is not insofar regarded as a matter of civil procedural law, but the idea is that inherent in the foreign judgment is a expression of will of the debtor party to pay the sum in question, respectively to behave in the way, in status decrees, to behave in the way the court has decided. And this, of course, is a totally new approach, which does not raise the issue of reciprocity at all, and insofar it comes as a surprise that nevertheless in the United Kingdom later on the reciprocity requirement was, at least for judgments sounding in money, introduced, and only in the field of judgments in rem, which means basically property law issues, where also a distinction has been made between recognition and enforcement. Only there, with the differentiation between movables and immovables, only there the reciprocity requirement was neglected or finally abstained from. In the new relevant act, namely the Civil Jurisdiction and Judgments Act of 1982, and in the Administration of Justice Act of 1920. Both are still in force and still govern the enforcement of judgments, not only with the regard to the United Kingdom and third states, but practically with any other Commonwealth courts. And here we find indeed the reciprocity requirement still in existence. The situation in the United States of America is particularly complex and complicated, as the judicial structure consists, as some of you will certainly know, of two different independent court structures and legal systems, namely the state courts and state laws on the one hand, and federal courts and federal laws on the other. State courts are bound by their respective highest state court and have to apply the laws of the state they are located in, whereas federal courts are bound by decisions of the Supreme Court and governed by federal statutes and the United States Constitution, of course. Federal courts have no jurisdiction, or let's put it the other way around. Federal courts have jurisdiction not only in all civil matters arising under the Constitution, laws, treaties of the United States, but also in state claims where the dispute exceeds a certain sum and citizens of different states are involved. This is a so-called diversity jurisdiction. Now, due to a number of decisions in the course already of the 19th and then the 20th century, to make a long story short, one can say that the reciprocity requirement has very well been established and upheld and maintained. There was a long story, and there was an up and down in several state courts, which partly decided contrarily to the federal courts. But I don't want to bother you with all the details. The main outcome is, after the so-called Hilton case, which has been decided in 1998, and which also led to a change in the restatement of the law second on conflicts of law. According to that, the reciprocity requirement is still vital and fully in existence. Now, dear students, dear colleagues, let us now come to general deliberations, considerations on the principle of reciprocity, which is so much contested these days, and which in a way constitutes a barrier with regard to the development and not only the doctrinal, but certainly also the practical treatment of our field recognition and enforcement of foreign judgments. As we have seen, the majority of jurisdictions in this world have very similar requirements of recognition and enforcement. Mostly, although with different, let's say, variations and approaches, every legal system requires the pronouncing state to have international jurisdiction and the judgment to be final and conclusive. We find that also, of course, in China. Then, practically in all of the states, also in China, we have the requirement that the judgments have not been acquired fraudulently and that they conform with its own public policy or ordre public. Those are, with slight differentiations here and there, the usual requirements. In one aspect, however, there is a crucial difference, namely the reciprocity requirement. Some have it and some have it not. Reciprocity insofar polarizes in the world, in the modern world. But make no mistake, although seemingly the Brussels 1A regulation appears to not insist on reciprocity, of course, reciprocity is inherent in this regulation because it is only a mutual concession of the sovereignty of the involved 28 member states. And the same thing is true with the Hague Convention on recognition and enforcement of foreign judgments, coming into force in 2023, hopefully, where we again can say that the reciprocity requirement is inherent in this convention among the convention signing and ratifying states. Now, this leads to the question that reciprocity in some countries matters with regard to third states outside conventions and bilateral treaties sometimes, and in some it does not matter. And that leads us to the question, are there good reasons and justifications for reciprocity? The requirement of reciprocity is usually explained and justified by its purpose to inspire foreign states to behave in a mutually beneficial way. It is, so to speak, an invitation to be friendly, a stretched out hand, so to speak. By demanding reciprocity, a state tries to encourage other states to recognize and enforce its decisions. If you have a closer look, though, this explanation and justification turns out to be weak and hardly convincing. Often recognizable and discernible behind this curtain of mutual benefit are motivations which are related to national dignity and honor and to the general interest of a state that its judgments are being observed and respected abroad, which means sheer sovereignty and sheer nationality. At least one must say the principle of reciprocity is not free from nationalistic emotionalism, which seems out of place today in today's international private law. Moreover, by offering reciprocity, a state might exert even political pressure on other states. Therefore, I am one of the strong advocates and of the protagonists of an abolition of the reciprocity requirement. And I can, I think, well justify that. So I may perhaps ask for your attention for this attempt to explain and to justify my stance. Look, from a private law point of view, and we are, after all, private lawyers, from a private law point of view, the principle of reciprocity does not add justice, but injustice to the recognition and enforcement of foreign judgments. Look, the person seeking recognition and enforcement in his favor has, after all, no influence at all on the reciprocity requirement. That one must fully realize. For him or for her, it depends on sheer accident whether or not the foreign state also recognizes and enforces judgments delivered by the state, where he is now seeking relief. From the private law point of view, the reciprocity requirement attaches, therefore, an unfortunate element of accident, of randomness to the outcome of the decision on recognition and enforcement. Moreover, requiring reciprocity in a way punishes the foreign judgment creditor for the attitude adopted by the rendering state. There is no reasonable explanation why the creditor should be held responsible for the state of the laws in the rendering state. Understandably, it has been called unfair to deprive him of the advantages of his judgment solely on the basis of the state of that law. Enforcement of judgments abroad serves to protect the foreign judgment creditor and should not be abused by the state for its political interests. The less so as reciprocity is beyond the control of the parties of the court. Generally speaking, dear students, the reciprocity requirement has nothing to do with our ideals and with our conception of private international justice. It is an alien principle stemming from and belonging to public law and to the arena of politics and diplomacy. Private civil proceedings strive, after all, to finally resolve legal controversies, finally, to conclusively clarify individual issues conclusively, and thus to put an end to the parties' dispute. The pursuance of these tasks results then in the rendered judgment in accordance with the general principles of private law, with parties' autonomy and the concept of fairness. Whereas the practice of reciprocity tends to ignore these fundamental principles of private law. You see, that is my point. The condition of reciprocity is, after all, an arbitrary and consequently an undesirable construct in private international law. Unlike other principles of international private law, such as the party's choice of law or the choice of jurisdiction, the principle of reciprocity is not negotiable by the parties, not negotiable. The reciprocity requirement disregards fully and entirely the parties' interests. It, so to speak, just employs politics. The question whether reciprocity is granted by the pronouncing court state is mostly accidental and lacks any reference to the present dispute. Also, as one can already see from my reasoning so far, the reciprocity practice in a way destroys or at least blurs the distinction between private and public law. Requiring reciprocity is more a political than a legal question. It is preferably and rightly seen as a foreign policy device to influence and to put pressure on other states. And the consequence is obvious. The reciprocity requirement entails a prosecution of public law interests by private law means, you see. Indeed, none of the principles of private law demand or even justify foreign judgments not to be recognized or enforced. Quite the opposite is true. For the party's interests is it does not matter whether the judgment was handed down or of which country the opposing party is a resident or a citizen. In demanding reciprocity, a state refuses to respect otherwise valid judgments just because it is naturally interested in having its own judgments recognized and enforced by the corresponding country. Now, given an appropriate separation and distinction between private and public law, recognition and enforcement could never be tied, could never be linked to reciprocity. It might be tenable to consider increasing leverage in bilateral and multilateral negotiations, a laudable objective in order to secure recognition abroad. Nevertheless, the desire to reach a just and final result between the parties to the private dispute without regard to the broader and the diplomatic relations of nations in which the tribunals reside is a paramount objective in private international law and should not be sacrificed to political aims. Now, one can also say that the reciprocity requirement does indeed constitute a severe barrier and impediment to international trade. It is, in fact, a non-tariff barrier to international trade. A practical issue and serious concern with reciprocity is already how difficult it can be to determine whether reciprocity is granted by the concerned state, since sometimes at least, for example, with regard to some of the African states, it involves a profound knowledge of the foreign procedural rules. It can hardly be expected of a court to be aware of the foreign law, especially in cases of a very exotic state. And this is often aggravated by language barriers, also by language barriers. Sometimes expert testimony is often necessary, which drive up court costs and prolong the proceedings, which already makes it clearly conceivable, if not obvious, that the idea of reciprocity constitutes a non-tariff barrier to international trade. And that is regrettable. That is most regrettable, since international commerce already benefits from various uniform codifications like the Uniform International Sales Law of Vienna, the Convention of 1980, you know, which constitutes almost a global sales law among the more than 80 conventional states, among them China. China was one of the first to sign and ratify the Vienna Convention. After all, uniformity of law simplifies international trade relations and provides for legal certainty, since both parties are aware of legal conditions and consequences, and insofar it makes it perfectly, I think, convincing that also in the field of recognition and enforcement, we should abolish the trade barriers of the reciprocity requirement. The more so, since imposing reciprocity is also, one must say, short-sighted for the states which still insist on this requirement, like Germany and like China, with regard to third states, you see. Since in the long run, it inevitably ends up in a no-win situation for all the participants. I can explain that. States may behave uncooperatively because they fear giving other states an advantage over them if they alone end up being willing to recognize and enforce. Or in particular theoretical consideration, this situation is known as the so-called prisoner's dilemma, the prisoner's dilemma. Suppose two states impose reciprocity as a condition to recognition and enforcement, like it is the case with China and with Germany. Neither state knows how the other deals with its judgment. Thus, in the situation where one state is requested to enforce the other's judgment, it examines whether reciprocity is granted. Now, if the answer is unclear, or if the other state does not grant reciprocity to judgments of the requested states, it will not enforce until reciprocity is granted. And the same thing is true for the inverse situation. Consequently, imposing reciprocity leads or can lead to a standoff in the proceedings. No one is willing to take the first step and enforce the other's judgments, but request the others to do so. Although one party can achieve an optimal result for itself by being egoistic, it amounts to a worse yield for them if both to do so. Taking into account these rules, the best result for both states can only be realized by a blind cooperation. Accordingly, a state should recognize and enforce foreign judgments regardless of the willingness of the other state to reciprocate. Remember perhaps our lecture on arbitration and on where I mentioned the New York Convention of 1958 on the recognition and enforcement of foreign arbitral awards, ratified by more than 150 states. This indeed accounts for this dilemmatic situation. Here, all awards are handed down by an arbitral tribunal, by private arbitral tribunal, or sole arbitrator, or an institutional court of arbitration, and cannot be regarded as acts of state. They do not derive from a foreign state. And there is no convincing reason to treat decisions rendered by a state court differently from those of private institutions, which reveals, in a way, the illogical use of reciprocity in matters of recognition and enforcement of judgments from a state court. Now, let me come to an end, dear students, so that we have still some time for comments, discussion, and questions, of course. The main point of my lecture today is relatively simple, and it is relatively unsophisticated, namely that the requirement of reciprocity is outdated, that it is redundant, and that it is superfluous. After having been abolished in the field of application of foreign law, in the field of private international law in the sense of conflicts of law, the reciprocity principle is now overdue for abolition in the field of recognition and enforcement of foreign judgments. In fact, we have seen that legal clarity, legal certainty, and efficiency are adequate and sufficient justifications for the recognition and enforcement of foreign judgments under the customary conditions. I don't want to name the name again, but one thing is to be sure, namely reciprocity need not and should not be an additional condition. The finding of my deliberations is insofar clear cut, namely the reciprocity requirement does more harm than good. Legislators should refrain from imposing it and favor facilitated recognition and enforcement. Yes, I do thank you for your attention in this respect. I hope we have learned something in this field, and I would like to invite you to ask questions, to give comments, and perhaps we can enter into a discussion.
Okay. First of all, we have to thanks for your wonderful lectures, and it has been lasting for almost 3 hours, so it's really not easy work, even for the audience, right? So thank you for your
sorry to trouble you.
Yeah, we all have felt your academic enthusiasm and sincerity. And today's lecture, Professor firstly have concentrated on the requirement for the regulation and enforcement of foreign judgment in China. So it's quite out of my expectation that Professor is so familiar with the relevant rules as well as the judicial practice in Chinese court. So that is quite out of my expectation. So you are a good professor in comparative law. Secondly, professor has also introduced the legal framework of the regulation and enforcement of foreign judgment in the European Union, especially in the Brussels system. Finally, I think the professor has most of the part has concentrated on the criticize the requirement for the reciprocity. As a matter of fact, for many years, China has insisted on the de facto reciprocity, which means that the Chinese court must make sure that foreign country have regularized Chinese, have such kind of precedents, right? And then Chinese court will regularize and enforce the foreign judgment. But in recent years, China has made great achievements in this respect. For example, after the regulation, first of all, the court in Germany, in in California, okay, in the United States, and in the Singapore, okay, many foreign courts have already recognized the mandatory judgment. I mean, that is not for divorce judgment, because in this kind of identification relations, the regulation of these identification relations does not require the reciprocity. I mean, the mandatory judgment. Several years later, Chinese court have also recognized the judgment rendered by these foreign countries, such as the mandatory judgment rendered by German court, right? By German court.
Well, it's interesting.
Yeah, and I noticed that in March 27 of 2022, in this year, the Shanghai Maritime Court have recognized and enforced the bankruptcy judgment rendered by the High Court of the England and Wales. So this has been the first case that China has moved to the de jure reciprocity rather than de facto reciprocity. So that's a great improvements, made for the Chinese court. In other words, China has adopted a more open attitude, towards the interpretation of the requirement of reciprocity. So I think I can't agree more with your opinions concerning the criticism on the requirement of the reciprocity. Okay, this is the I have made a brief summarization of the lecture given by a professor. Okay, so the audience, if anyone got any questions for professor? Okay, has, okay. Learner, right? Learner. Okay, okay. You can have got some questions for professor. Okay.
Please go ahead.
Thank you so much, Professor Martinex. Thank you so much. Thank you for your insightful and enlightening lecture. But there is a question from me based on the two aspects of recognition and enforcement. Recognition always comes first, enforcement second, and some judgments are only for recognizable purposes, not enforceable purposes. And could you please make a hypothesis related to the potential power of reciprocity, which is relatively fragile, invisible, but inherent in providing legal certainty, clarity, and efficiency, whether its role is to be minimized or optimized in the future under the current globalization situation, and the principle of reciprocity is inherent. How could it be abolished? Is it a little bit paradoxical? Thank you so much. That is my question.
Yes, I fully understand this question, and I think it is a well-justified question because, as you rightfully emphasized, in the international agreements, particularly in the multinational conventions, as well as in the supranational regulation of Brussels 1A regulation, the reciprocity requirement is inherent. And insofar we are dealing here only with situations, dear student, with third states where there is no agreement and no treaty and no consensus so far being established and insofar being in existence. No doubt there are some countries, particularly in Africa, but also partly in South America, which are trade partners of particularly countries like the ones of the European Union, but as well as of China, where this issue can easily come up, so to speak, third states. And now you are in a, one can say, ambiguous, no doubt, ambiguous situation. How can you win these countries to join the community of the states that among each other recognize and enforce the other states' judgments without looking at reciprocity? And insofar, my attempt and my pleading, or my judgment, or my, one can say, approach is basically that the one state should not insist on reciprocity, should not look at this requirement, and hereby make a first step to also include the other states into this community. Once this has been made, then I think a step forward has been taken. Even then, if the other state does not react properly and as expected, namely, even if the other state insists still on a non-application. And insofar, I think it is just a matter of the first step. And it is not contradictory, but it is a approach to widen the community of the accepting states. You are, on the other hand, right. Once this community has been fully accepted, then one can say the reciprocity principle is inherent.
Yeah,
right.
Sure, yes.
One, that is for sure. But on the other hand, it still doesn't matter. It, so to speak, is not a defense anymore. And it cannot be activated. It is not only, it is, although it is inherent, it is silent. It is then silent and does not matter anymore, because nobody activates it. Nobody tries to invoke this principle as a defense, you see, because they all agree on mutual recognition and enforcement. Nobody will ever raise the issue of the principle of reciprocity anymore. So it doesn't matter that it is inherent, because it is, so to speak, silent, not active, and dead. It is inherent, but dead. That's the idea, you see?
Well, thank you. I do think that you wanted to be the pioneer in leading some ways. And I do understand that. Thank you for your comprehensive answers for my questions. And thank you so much. I have to say that I'm an amateur in this field, but I'm so lucky to listen to your lecture this time. But maybe next time I would like to know more. And thank you so much again. Thank you.
It is a great pleasure to teach you.
No, maybe next time, maybe we are the teachers for each other. Maybe next time. I mean, next time. Okay. And thank
very
you.
Good,
thank
very
you,
good.
Professor Martinek. Thank you.
Okay. Anyone else? Okay, if anyone have questions, please go ahead.
Yeah. As you rightfully put it, dear colleague Chui Huang, the lecture is a little bit long, with almost 3 hours. The more so, since I do not make a PowerPoint presentation and fully concentrate on the power of the words, that exhausts a little bit the attention of and the reception, so to speak, of the audience. So it comes as no surprise that nobody is willing to ask any more questions now. But I think we have already learned a lot. And what remains is to invite you to my next lecture on Thursday, the day after tomorrow, same time, where we will be dealing with the determination of jurisdiction in particularly international controversies, and also with some other principles of civil procedural law then.
Okay. Lastly, I would like to express our sincere gratitude for Professor. And we hope that we can invite you to our university for offline communication after the ending of the pandemic. Okay, and also thanks for all the participants, okay, today. Okay, thank you all of you, and have a nice day. Bye, Professor.
Goodbye, thank you so
Bye.
much, and I wish you
Okay.
all the best. I hope to see you again.
Yeah.
Stay
Okay.
well. All the best. Goodbye. Goodbye.
Okay, all the best, Professor. Okay, thank you for all of you. Okay, to participate in
Thank
the
you
lecture
to the
today.
audience.
Okay.
A big thank you to you, all of you.